My name is Laura Johnson. Welcome to this Deka, which is on the topic of secondary victim claims and where we are now following the Supreme Court decision in the case of Paul. I'm really delighted to be joined today by Phil Barnes, who is Head of Medical Negligence at Shoosmiths. And together we have represented the Paul family throughout the litigation that led to the recent Supreme Court decision, and indeed continue to do so because there remains an underlying clinical negligence claim. I also must acknowledge the other member of the team who's not with us today, Rob Weir KC, who came into the case for the Court of Appeal in the Supreme Court, and he was fantastic both as an advocate and in all of his efforts for the Paul family. But Phil and I thought we would do this webinar together because this is a journey that the two of us have travelled from the very beginning. And we're also going to break from webinar tradition in that we have decided today that as we're sort of having a bit of a conversation, although there's going to be long bits of me talking because Phil has very kindly let me deal with the law, of which there is a lot. We're not going to have slides, but no need to panic for two reasons. One is there will be a YouTube link of this webinar that will be circulated to you all by email, but also in light of the importance of the decision in Paul, both in the clinical context, but also to secondary victim claims more generally, I have prepared a paper with the title Secondary Victim Claims, Where Are We Now?, which has I've had a huge amount of assistance in doing from Francesca Kolar, who is a colleague of mine at Deka Chambers. So that will be circulated to you all with the YouTube link. It will also be available on the Deka website and through our various mailing lists. And that paper essentially covers the material that we are going to talk about today in a bit more detail, explaining the law on secondary victims and the consequences of the case of Paul, all reduced to a pithy 12 pages. Now, because Phil and I have come to this case from a slightly different perspective of having lived it for the last 6 years, we thought we'd take a slightly different approach to what we're going to cover today. We will, of course, cover the decision in Paul, the consequences of it, and we're going to conclude the day by having a discussion about what we think it means for cases in both the clinical and the personal injury context. But we thought we would also share some of the history of the case as it's wended its way through the courts. And Phil is going to share with you some of the insights from a solicitor's perspective of managing a case that starts out, as all cases do, as another case that is, of course, important, as all cases are, but suddenly becomes a case of wider public and legal importance, and the impact that that has on how you manage everything that is going on in the background. So in terms of what we're going to cover today and the order of things, we're going to start with the background to the case. What is Paul about? Looking at the facts of it and the underlying clinical claim. What was the issue in the original strikeout application? I'm going to do a brief tour of the decisions of Master Cook, Mr. Justice Chamberlain and the Court of Appeal, because of course the Supreme Court decision in Paul was the fourth judgment in that case. Phil's going to talk a bit about litigating in the Supreme Court from the solicitor's perspective. We're then going to look at the decision in Paul and what was decided. And as I said, at the end, we'll conclude with a discussion about what we think the impact is for claims going forward, both clinical and personal injury. So with that covered, I'm going to hand over to Phil, sorry, Phil, and start with this. Phil, would you like to start by just sharing some of the background facts of the case of Paul?
Yes, yeah, of course. So Parminder Paul, he was diagnosed with type 2 diabetes, high blood pressure, retinopathy, neuropathy, and he had chronic kidney disease. And on the 9th of November, he was admitted to New Cross Hospital in Wolverhampton as an emergency with chest and jaw pain. And he had an elevated troponin level, a borderline ECG, he had an echocardiogram performed, and they treated him for acute coronary syndrome. And the plan was for him to have a dobutamine stress echocardiography as an inpatient, but there was no plan at that stage for a coronary angiography. The dobutamine stress echocardiography was not available whilst he was inpatient, so he was discharged on the 12th of November. He came as an outpatient to the hospital on the 16th of November and underwent a standard treadmill test. where he had some jaw pain on exertion, and he had the debutanine stress echocardiography on the 13th of January, which was negative for inducible ischemia, but he was given some medical treatment. Statins were recommended. And roll on a few months, in the spring of 2013, he started to suffer deterioration in his kidney function. He had hemodialysis, and they were discussing renal transplantation. And as part of that process, he was referred for a cardiology review. That cardiology review happened on the 9th of January 2014, and decision was made for him to have an elective coronary angiography a few weeks later. On the 26th of January, Parminder was out shopping with his daughters, Maya, who was age 9 at the time, and Saffron, who was 12, and he complained that he felt ill. Maya was walking slightly behind him, and Saffron slightly in front. And as Saffron turned around, she saw her dad leaning against the wall, his eyes rolled back, and then fall backwards and strike the floor. Saffron tried to call her mum and an ambulance, but in her panic state, she was unsuccessful. The street was quite empty at the time, and they were shouting for help. And eventually, a lady arrived and called an ambulance. Maya, when she tried to call her mum, was so distressed, her mum didn't really understand what was happening. And so Saffron took over the phone and told her mum. And then they were ushered into a nearby church by members of the public. Then they heard their mum scream their father's name, and they went out and witnessed the ambulance crew performing chest compressions. And then Mr. Paul was taken to hospital for further resuscitation, but they thought that was futile, unfortunately passed away. So Maya and Saffron effectively witnessed the heart attack, the collapse and death of their dad.
In terms of the case, Phil, could you just give us a really brief description of what the underlying clinical case is then?
So the claims brought were under the Fatal Accidents Act 1976 and the Law Reform Estates Provisions Act for the dependents and of the estate, and obviously secondary victim claims were brought for Maya and for Saffron. And the allegations made in the clinical negligence case are that the defendant failed to heed Mr. Paul's multiple risk factors for the development of coronary artery disease, and also failed to heed that when he presented in November 2012, he was presenting with typical coronary artery disease, and they failed to perform a coronary angiography during that admission. In terms of causation, we allege that had that angiography been performed, it would have revealed significant coronary artery disease. In fact, the post-mortem report showed that he had left ventricular failure, ischemic heart disease, and occlusive coronary artery atherosclerosis. And had they performed the coronary angiogram, they would have performed coronary revascularization, which would have been successful, and that would have avoided his cardiac arrest and death on the 26th of January. And tied on to that case, of course, we bring the secondary victim claims. Both Maya and Saffron, it's their father, so they had close ties of love and affection with their father. They witnessed his collapse, the attempts at resuscitation, his death, and what we allege what they witnessed was the first manifestation of the defendant's breach of duty, which was both horrifying and shocking. So that's the facts, Laura. Do you want me to go on and just give a timeline of where we were in terms of from the start of the case up until Master Cook's decision?
I think that would be useful, because one of the things that I think has been striking for both of us throughout the life of this case is what a big ask it is for families when an issue like this arises and essentially throws the brakes on the underlying clinical claim. So I think just a brief timeline of how long this has taken to come to the point that we've reached would be of interest.
Okay, so we served the letter of claim on the 30th of November 2016. Letter of response came through on the 16th of March 2017, denying liability. Proceedings were then issued on the 25th of October. At that point, Maya was 13 and Saffron was 16. And then we served proceedings on the 25th of May 2018. The defence then sought a 6-month extension to file the defence, and they got Saffron and Mai examined by a psychiatric expert. They then sought a further extension to file the defence the 1st of March, but without prior notice on the 26th of February 2019, they applied to strike out both Maya and Saffron's secondary victim claims. No defence had been filed at that point, and that leads us to the strikeout application, which was before Master Cook on the 11th of October 2019.
Thanks, Phil. So I think it would be useful now to look at, first of all, what was the issue in the strikeout, and then in order to understand that, for those of you who are less familiar with the law of secondary victim claims, what the strikeout meant in terms of the test that was to be applied. So I've dug out the original application, which was impressive in its brevity. And all it said was that the claims were misconceived in law because they could not satisfy the control mechanisms in Alcock, and as such, no duty of care was owed to the girls. And then it says reference is made specifically to the proximity and shock in law requirements as considered particularly in Taylor and Somerset Health Authority, a case which formed the basis for and was expressly approved of by the Court of Appeal's decision in Taylor and A. Novo. So that was what we had in advance of the hearing before Master Cook in December 2019. Now, it seemed to me it'd be useful to cover, as I say, some of the background, starting with what is a secondary victim. A primary victim, as you will probably all know, is a person who is injured by the negligence of another, and most compensation claims that we deal with are concerned with primary victims. Secondary victims are an exception to the general rule that the common law doesn't recognise one person as having a legally compensable interest in the physical well-being of another. And it's that rule which explains why a person who, for example, a mother suffers psychiatric injury as the result of caring for a devastatingly injured child who has been injured through the negligence of another, can't bring a claim for that. The exceptions to that are secondary victim claims and also the statutory cause of action for bereavement under the Fatal Accidents Act. Now, over time, the law has developed to allow this class of claimants known as secondary victims to bring claims where they have been no more than the passive and unwilling witness of injury caused to others. And that's a quote from Lord Oliver in Alcock. And I should say at this point, when I was at law school doing my law conversion, I decided that I would rather learn the law of nuisance than the law of secondary victims as part of my tort exam preparation, because I found the law of secondary victims so difficult to understand. So there's a certain irony that over the last 5 years of my life, it has taken up quite such a large part of my practice. However, it's important to recognise that the secondary victim's claim is not parasitic on the claim by the primary victim. And one of the issues that was of importance in the Supreme Court decision in Paul was that there may not in fact be a primary victim. So your secondary victim may have suffered as a result of seeing injury or death to somebody that they love, but they also may have suffered injury as a result of simply seeing imperilment to somebody who themselves does not end up being injured and therefore doesn't have a claim. So what you have to show to establish a secondary victim claim is that sufficient proximity exists between the claimant and defendant so that a direct duty of care between the two of them arises. And the famous quotation about this that also comes from the case of Alcock is this one. The description secondary victim must not be permitted to obscure the absolute essentiality of establishing a duty owed by the defendant directly to him, a duty which depends not only upon the reasonable foreseeability of damage of the type which has in fact occurred to the particular plaintiff, but also upon the proximity or directness of the relationship between the plaintiff and the defendant. And what we've been concerned about in this appeal is this question of proximity and the directness of that relationship between the plaintiff and the defendant, because over time the law has developed to create mechanisms to help the courts decide whether that proximity exists. While we're on this introductory topic, it's important to note that in the early 1980s, the area of law extended one step further to enable those who hadn't witnessed the primary event but had come upon its immediate aftermath to bring the claim in certain circumstances. We've taken to referring to this as the immediate aftermath extension, and it comes from a case called McLaughlin and O'Brien. Some of you may remember this case where a mother came upon the surviving members of her family who'd been involved in a road accident in hospital, still described as covered with oil and mud and distraught with pain, so the condition that they should come upon them at the roadside. And in McLaughlin, it was decided that she should be able to recover. So what are the control mechanisms? Well, in order to understand Paul and its impact on the law of secondary victim claims, we need to have a quick tour of the authorities in which the type of claim developed, because it is an area that is influenced by public policy, and as a result, it doesn't follow the familiar gateways of the law of negligence. Now, in terms of understanding how the courts have decided that secondary victims must show proximity in the relationship with the defendant to establish that duty of care, the issue is governed by the case of Alcock and the Chief Constable of South Yorkshire Police, which is essentially derived from the authorities before that. So we've just touched upon McLaughlin. In that case, Lord Wilberforce identified 3 elements in any claim which had to be considered to keep the liability of defendants within reasonable bounds. The first was the class of persons whose claims should be recognised. The second was the proximity of those persons to the accident. And the third was the means by which the injury was caused. Now, Alcock is a very famous case. It was decided 9 years after McLaughlin. And most of you will know that it arose out of the dreadful Hillsborough disaster in 1989, when 97 Liverpool football fans died and others were seriously injured at the Hillsborough Football Stadium in Sheffield. The claimants in that case had various different experiences of witnessing the events. 2 had been present at the ground and witnessed the crush. Others saw the disaster unfold on the television. 3 of the claimants identified the body of their relative at the mortuary. The House of Lords held that none of the claimants were entitled to succeed. It's quite a difficult case in some respects, because 4 out of 5 members of the appellate committee gave reasoned speeches and there is no clear lead speech. But in subsequent cases, it's that of Lord Oliver that has attracted the greatest attention. Now, Lord Oliver's speech is the origin of the distinction between the use of these words primary and secondary victims, identifying broad categories of cases where the claimant was involved, either immediately or immediately as a participant, a primary victim, and those where the claimant was the passive unwilling witness of injury caused to others, the secondary victim. And Lord Oliver emphasised that reasonable foreseeability of harm alone, whilst a necessary ingredient of the duty of care, will be familiar as tort lawyers, is not in itself sufficient. There must be this concept of proximity. And what the law is looking for in this regard, often judges turn to the classic description of proximity contained in Donoghue and Stevenson, the famous snail case. And that is that you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. Who then in law is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I'm directing my mind to the acts or omissions which are called into question. And essentially the issue that the Supreme Court was grappling with was whether Meyer and Saffron would fall into that category or not. Now, Lord Oliver went on to identify the common features of the previous reported cases where claims had succeeded, and these are what have come to have been known as the control mechanisms. So a marital or parental relationship between the claimant and the primary victim, that the injury claimed arose from the sudden unexpected shock to the claimant's nervous system. The claimant was either personally present at the scene of the accident or was more or less in the immediate vicinity and witnessed the aftermath shortly afterwards. The injury suffered arose from witnessing the death of or extreme danger to or injury or discomfort suffered by the primary victim. And lastly, there was not only an element of physical proximity to the event, but a close temporal connection between the event and the claimant's perception of it, combined with a close relationship of affection between the claimant and the primary victim. And he said that from these elements, the essential requirement of proximity is to be deduced. Now, this went on to be considered in a second case concerned with the Hillsborough disaster, which was that of Frost and the Chief Constable of South Yorkshire, which many of you will know was concerned with claims by police officers who were present at the stadium and brought claims for psychiatric injury. And it's in the case of Frost that both Lord Steyne and Lord Hoffman distilled down those principles identified in Alcock to the control mechanisms that we're familiar with today. And just to close off on Frost, many of you will know that those claims were unsuccessful because the police officers were unable to satisfy the requirement of having a close tie of love and affection with any of those killed or injured. Now, for the clinical negligence practitioners amongst us, these cases have then led to development of secondary victim claims in the clinical context. And there's been a number of cases of importance that I will touch upon briefly because they are important to the reasoning of what happened in Paul, but I won't go through them in exhaustive detail, you'll be happy to know. The first was a case called Taylor and Somerset Health Authority in 1993, which I don't think is that long ago, but I realise it's 30 years ago, so it's quite a long time ago. And this was of essential importance in the early arguments of the NHS in Paul, and remained important up to the Supreme Court, because it was concerned with a case where a woman had been told that her husband had died of a heart attack at work and saw his body in the mortuary soon after his death from a heart attack. So essentially it was an immediate aftermath extension case. And the defendant admitted the death was caused by its failure to diagnose or treat the serious heart disease months earlier. It was accepted that there was a causal link between what she had witnessed and the psychiatric injury. But Mr. Justice Auld held the claim failed for two reasons. The first was that the test required some external traumatic event in the nature of an accident or violent happening, and there hadn't been such an event. Rather, the death was the culmination of a natural process of heart disease. The second reason was that even if the husband's death could be regarded as a qualifying event, the doctor's communication of it to the claimant at the hospital and the subsequent site in the mortuary didn't come within the immediate aftermath extension recognised in McLaughlin. Now, for every case in favour of one side in this area, there's a case in favour of the other side. And the case that was of essential importance to the arguments on behalf of the claimants in Paul was a case called North Glamorgan NHS Trust and Walters. And this was a case about a little boy called Elliot, who had died following 2 days of seizures. His mother had been with him in hospital throughout that period of time. And the issue the Court of Appeal was grappling with was a slightly different one, which is whether the claimant's experiences over that 36-hour period could be regarded as one entire event. And the conclusion of the court was that it could do. And it was important to our arguments that on the facts of Walters, the baby had become ill some weeks earlier as a result of a failure to diagnose and treat him with a kidney transplant. And the event that the court accepted was the event for the purposes of the secondary victim claim. Started those weeks later and continued over that course of 36 hours until the baby died. And it was our position that in order for our argument to be wrong, then Walters must have been wrongly decided, and ultimately, as I'll come to, the Supreme Court decided that it was. A few other cases are dealt with in more detail in my written note. There's a case called Renane, which was about the misplacement of a suture causing peritonitis, and a case called Shorter and Surrey, where the primary victim should have been transferred for urgent neurosurgical treatment. Both of those claims failed for want of what was thought at the time to be required, which was sudden and direct appreciation of a sufficiently horrifying event. But in neither of them was a point taken about whether or not the claims as a matter of principle could go forward based on the effect of the failure to treat being the relevant event. So that's my tour of where we got to before we appeared before Master Cook in 2019. Now, the way the case has been put on behalf of the defendant, and that absolutely no criticism of this, has varied in time as it does when a case proceeds through many levels of argument at different levels of court. And of course, the level of court has been relevant to the arguments because it has dictated what the judge at any particular time has been bound by. But before Master Cook, the NHS argued that the court was bound by Taylor and Somerset, that it was all on all fours with the facts of Paul, and the ratio of Taylor was that a death from a heart attack could never amount to a relevant event for the purposes of the test of proximity. And Master Cook concluded that in order to establish proximity, there needed to be a connection between the initial negligence and the shocking event, and that with a gap in time of 14.5 months between the negligent incident and the heart attack could not be said to be the relevant event. So aspects of the argument were similar, but aspects of it were quite different. Now, that then led So we were struck out by Master Cook at that point in time. And that led to Phil and I having to make some decisions about what we were going to do about it. And the management of the case in the background. And Phil, I wanted to bring you back in here to discuss why we decided that this was an issue that we ought to appeal, what we felt was important about it.
Well, I think it's just the inconsistencies we had in the law at that stage between Taylor and Novo and Walter's decision, and the fact that on a practical application we were seeing quite a number of challenges from the defendants on these points, strikeout applications being made, etc. And I think that from a practical point of view, we needed clarity for the lawyers, for the client, bringing these cases to understand what the law said. So we obviously felt that Master Cook's decision was wrong, and this was an opportunity for us to make an application to appeal that decision and get authority from the Higher Court. And of course, it was driven by the client as well. The client wanted to appeal this decision. Yes, it was the clarity we were seeking, but also we felt that this area was being wrongly interpreted.
It was difficult, wasn't it? Because I think your experience was the same as mine at the time. We would have some cases where a secondary victim claim would settle without any objection being brought at all. In other cases, I mean, for me, Paul was the first time I found myself on the receiving end of a strikeout application in one of these cases. But that inconsistency not only made it difficult to advise, didn't it? But it also seemed very unfair that some claimants were having their claims settled and others were meeting this sort of response. So we decided to appeal. Permission was granted in January 2020 by Mr. Justice Stewart, who recognised that although on the face of it a case called Taylor and Novo appeared to dispose of the case in the defendant's favour, there were factual differences, that the facts in Walters were described as not clear, and there were dicta in other cases that led to a conclusion there should be a full hearing. And this led to the argument that we had in front of Mr. Justice Chamberlain, which was in May 2020, and very soon after the first pandemic lockdown. So it sticks very firmly in my mind because it was the first properly remote hearing I'd done. I had to anxiously drive myself into London, desperately hoping I wasn't stopped and going to have to explain my key worker status because my internet connection wasn't good enough at home. And at the time, it was a very alien way of working. And I have to say, absolute credit to Charles Baggett, KC, who put together the first properly electronic bundle I dealt with. Charles was my opponent through the early stages, continued through to the Supreme Court, and was an absolute delight to be against throughout. And to our delight, we succeeded in the appeal before Mr. Justice Chamberlain. Again, the arguments were somewhat different from where we ended up in the Supreme Court. The focus of the defendant's submissions at that stage was that the daughters were not present at the scene of the tort, which was said to have been at the hospital, and therefore no shocking or horrifying event had occurred for them to witness, and therefore they couldn't recover. Mr. Justice Chamberlain analysed the case of Taylor and Novo, which was a Court of Appeal decision, the one that approved the Taylor and Somerset decision. And that's a case that was concerned with a woman who'd been injured when some racking fell on her at work. And she had appeared to be recovering well from that. And then 3 weeks later, she collapsed and died in front of her daughter as a result of a pulmonary embolism caused by a DVT as a result of the initial accident. And the Court of Appeal decided in Taylor and Novo that the daughter couldn't recover because she had witnessed the consequences of the first event and not the relevant event itself. And Mr. Justice Chamberlain analysed the ratio of Novo as being that in a case where the defendant's negligence results in an event giving rise to an injury to a primary victim, a secondary victim can claim for psychiatric injury only where it is caused by their witnessing that event rather than any subsequent discrete event, which is the consequence of it, however sudden or shocking. So essentially his view was you could have one event and that was it. And that in Paul, there was only one pleaded event, which was Mr. Paul's collapse and death from heart attack at which his daughters had been present. And as a result, where there hadn't been a previous event akin to the collapse of the racking in Novo, he found that the failure to diagnose Mr. Paul's heart condition couldn't be considered to be an event of that sort. Then Novo wasn't a bar to recovery. And he also accepted the argument, even if there had been some symptoms prior to the heart attack, that wasn't a bar to recovery because it would place it on all fours with the case of Walters, which of course he was bound by. So that was Mr. Justice Chamberlain's decision, which I think it's fair to say, Phil, we would describe as the high point in our journey in the case of Paul. And that was followed that was followed by consideration about what was going to happen next and the involvement of two further cases, the case of Purchase, which had been decided in May 2020 after Master Cook's decision striking Paul out, but before the judgment for Mr. Chamberlain was handed down. And then the case of Paulmere, which was decided by Master Cook after Mr. Justice Chamberlain's decision in Paul. And I think it's fair to say, and there's no criticism attached to this, it's just a fact, that the introduction of two more cases with different and perhaps more complex facts created complexities for the arguments for the claimants. So that took us to the Court of Appeal in December 2021. And I'm not going to say a lot about the Court of Appeal's judgment. They considered that they were bound by the case of Taylor and A. Novo, and that Taylor and A. Novo was a bar to recovery for the claimants in these cases. The reasoning about the ratio in Novo, I think, is a bit questionable in the Court of Appeal, and certainly the Supreme Court placed a different interpretation on what the ratio of that decision was. But what is interesting about this area of law, being essentially policy driven, is that it does enable courts to express views about what the law should be based on their own particular views about where justice lies. And it's striking that in the Paul case, both Mr. Justice Chamberlain and the justices in the Court of Appeal felt that the justice of the case lay in favour of allowing the claimants to pursue their claims. But then, as we all now know, the view of the Supreme Court was the opposite. And this is one of the difficult features of judge-made law, particularly in marginal cases, that one person's justice may look very different to another's. And I think it's fair to say, in relation to the points that the Supreme Court make about where the justice of the case lies and what the reasonable person might think, whilst many of the points they make one can't argue with in and of themselves, there is often a counterpoint point of view depending on whose perspective you look at the case from. So that took us to the decision, the conclusion of the decision of the Court of Appeal, which was that the claimants had lost, but the court doubted that Taylor and A. Novo was rightly decided, and they gave us permission to appeal to the Supreme Court, with Lord Justice Underhill saying in terms that if the point was free from authority, he would be minded to find the claimant should recover. And Phil, I wanted to bring you back in here to just share some of your thoughts about taking a case to the Supreme Court from the solicitor's perspective before we move on to looking at what the Supreme Court decided in the case of Paul.
Yeah, well, obviously I've never been to the Supreme Court before. Probably won't go again, but you know, just going back the timeline, it was such a long time period between when we had Master Cook's decision back in November 2019 to when we got to the Supreme Court in May 2023. So you know, that long time period is quite difficult to manage the client, and of course in between all of that we've got the clinical negligence claim that at this point had to be parked or stayed as it was, whilst we dealt with the secondary victim appeals. And it's difficult to manage the clients during that process. I mean, the clients we had were fantastic. Initially, we started off with Barry Paul, who was the wife of Parminder and the mother of Maya and Saffron, who was giving us instructions. But obviously, as the case progressed and the years went by, the Maya and Saffron, you know, turned 18. So they then, by the time we got to the Supreme Court, were both giving instructions to us, and for them to hear their story being told at different levels and different courts, it's quite difficult, because it was just they were just reliving the experience, and to listen to the arguments as to why they shouldn't be entitled to recover for the events they witnessed is quite difficult. So I think it was a really traumatic time for the family going through that experience themselves, and it's over a long period. But they were strong and very determined that they wanted to get some clarity in this area, because they didn't want other families to be going through the same as they'd been going through. They wanted to just get some certainty, which obviously the Supreme Court has delivered to an extent now. In terms of, so from the family's perspective, it was really a roller coaster journey, a very emotional journey. And the case, of course, the clinical negligence case is still ongoing, so we've not quite got to the end of that yet. But it's the journey's ongoing. But the second victim claim journey has come to an end. In terms of from a practical application from solicitors' perspective, obviously the Supreme Court have their own rules, practice directions, and those are things that you have to learn. And get to grips with. And of course, COVID changed the way that the courts were presenting documentation and bundles. And there was guidance on producing electronic bundles, which actually differed slightly from the practice direction, which made things slightly confusing. But as Laura said about Charles Baggett's role, actually, we worked very closely with Brown Jacobson, who were the defendant firm on Paul, and really had a good working relationship with them to try and get the bundles together. And of course, the other claimants in the appeal as well. So we worked really all very closely to get everything into the Supreme Court, and I think the bundles worked really well. But it was an experience, and one whilst learning new rules is quite difficult and getting to grips with the practice directions. What was refreshing for me was the actual response of the registrars in the Supreme Court. The experience you have there is completely different to the courts. Emails were responded to within minutes, hours, and any problems you had, you were able to speak to somebody directly. So it was a real positive point, being able to work with the Supreme Court.
So what you're all keen to know about is, what did the Supreme Court decide in Paul? And I think what was interesting for us, once we could bring ourselves to read the judgment, having discovered which way it had gone, was that the court did deal with the key question that it was facing, which is, whether or not the Alcott criteria would embrace individuals who had been injured as a result of seeing the effects of an untreated illness to their loved one. But also the Supreme Court took the opportunity to look more widely at how some of the control mechanisms have been interpreted by lower courts, in particular in the clinical cases, and to reset how some of those control mechanisms should be interpreted going forwards. Now, the main takeaway that you need to take away from the case of Paul is that in order to bring a secondary victim claim, the claimant must have witnessed an accident or its aftermath caused by the defendant's negligence. So the court has restricted secondary victim claims hugely from where I think many of us thought they were. What do they mean by an accident? The definition is touched upon in different contexts, and as I say, this is all covered in my paper, but I think probably the best definition comes early in the judgment when they're discussing earlier secondary victim claims arising out of the paradigm cases, the accident cases, and the Supreme Court describes using that term in its ordinary sense to refer to an unexpected and unintended event which causes injury or a risk of injury to a victim by violent external means. Now, as lawyers, we're used to trying to stretch definitions of words to try and suit our particular case, but that is a restrictive definition of an accident, in particular by the reference to violent external means. Other parts where they touch upon it in the judgment are these. So when they were considering the cases of McLaughlin, Alcock and Frost, all cases where the underlying event was described as an accident in the sense already mentioned that it was an unexpected and unattended event which caused injury or a risk of injury by violent external means to one or more primary victims. And then one of the things that we'd all been arguing about, because there was, you'll see from the judgment, loose language in the judgments between accident, event of injury. When discussing the distinction between first manifestation of injury and an accident, the court observed that the occurrence or first manifestation of injury is not part of what defines an accident. An accident is an external event which causes or has the potential to cause injury. It is not the injury, if there is one, caused by that event. And then later on, when they're discussing the benefits to legal certainty of restricting the claims to accidents, the court said an accident is by definition a discrete event which happens at a particular time, at a particular place, and in a particular way. So that is now what we are looking for in order to be able to establish the basis of a secondary victim claim. Now, the court gave a number of reasons why it considered that witnessing an accident was legally significant. The first is certainty. They thought that an accident was pretty readily clear. So that this is the bit I've just given you, a discrete event in a particular time, a particular place, in a particular way. Whether someone was present at the scene and whether they directly perceived an accident are in most cases questions which admit of a clear and straightforward answer. And then witnessing an accident involving a close family member is itself likely to be disturbing and upsetting event, even if that person in fact escapes unharmed, and all the more so if that person is physically injured or killed. So another reason why they felt the accident in itself was important, that accidents are often, in the view of the Supreme Court, upsetting by and of themselves. As personal injury lawyers, we might not necessarily agree with that, but that was thought to be important. And then thirdly, and interestingly, they said that one of the other reasons is that there can be difficulties distinguishing between primary and secondary victims in accident cases, which militates in favour of allowing recovery in accident cases, but not otherwise. And here's a quote: in a case where, for example, both a mother and her child are put in physical peril, it would not only be unjust, but practically impossible to distinguish between the mother's emotions of fear for herself and fear for her child. Now, of course, that's not something that applies in many accident secondary victim cases. There doesn't need to be any physical threat to the parent or the person witnessing the accident, but they felt that that was important. In contrast, reasons why not to allow in those cases that didn't have an external violent accident. It can be more difficult to identify a discrete event, in many cases involving a medical crisis. And whilst they felt that the facts of Paul with a readily identifiable event was one thing, there were other cases, in particular those demonstrated by Waters and Shorter and similar cases, where symptoms of injury or disease may be variable, potentially being minutes, hours, days or weeks, giving rise to uncertainty about what would qualify as an event. It was our argument in Paul that judges are used to making these sorts of assessments in cases in trial, for example, deciding whether the requirement of the close time, love and affection is met, and that really one knows these things when one sees it, but that didn't find favour with the Supreme Court. They also thought that the extent to which the experience of witnessing injury or illness and whether it's traumatic is variable. And the court felt that an adequate test hadn't been identified to distinguish between those cases that could found a claim and those could not. Again, one could say the same for accident cases. There are some cases where obviously it's traumatic and others where it's more questionable, and the courts have to grapple with these issues, but they felt that was important. And then that the difficulties with distinguishing between primary and secondary victims don't arise in medical cases. And then the court raised two further justifications for drawing the line at claims arising out of an accident: a qualitative assessment that an ordinary reasonable person would think that it was unfair for a daughter to recover damages for seeing a parent die from a heart attack or pulmonary embolism, but a mother denied for recovery where she identifies the mutilated body of her child in a mortuary or is present at the hospital many days after an accident when the child dies from his or her injuries. Now, I think this really turns on whenever you draw a line, there's going to be people where it feels unfair, they land on the other side of it. And I think one can argue the case on where that line should be drawn, and indeed we did. And then the court felt that it was undesirable for decisions about end-of-life care to be complicated by the risk that if it said the death ought to have been prevented, the hospital will be exposed to potential legal liability to family members as a result of them seeing and remaining with the patient. So that is the key part of the decision in terms of why it impacts on clinical cases, because clearly in the overwhelming majority of clinical cases that accident won't have occurred. And the court then decided to test its conclusions against the framework of the circumstances in which a doctor owes a duty of care to third parties, and concluded this: common to all cases of this kind, however, is a fundamental question about the nature of the doctor's role and the purposes for which medical care is provided to a patient, we're not able to accept that the responsibilities of a medical practitioner and the purposes for which care is provided extend to protecting members of the patient's close family from exposure to the traumatic experience of witnessing the death or manifestation of injury or disease or injury to their relative. To impose such a responsibility on hospitals and doctors would go beyond what, in the current state of our society, is reasonably regarded as the nature and scope of their role. And then they went on to say that such an experience, witnessing that death from disease of a close family member, is not an insult to health in which we expect doctors to take care to protect us, but a vicissitude of life which is part of the human condition. Now, I don't think anybody would disagree with that, but of course the difference in this case is that these are deaths or injuries that ought to have been prevented by competent medical care, and that is something that isn't expressly referred to in that aspect of the judgment. So I think that is a part of the judgment that might grate with some. Now, what is the effect of this decision on earlier key authorities? Well, the court said Taylor and Novo was clearly rightly decided because it's an accident case and the daughter didn't witness the accident. She witnessed a consequence that followed thereafter. The court held that Walters was wrongly decided and concluded that Shorter, Sion and Ronayne were all rightly decided but on the wrong basis. All of those cases should have failed because there was no accident, and it's as simple as that. So that was the main issue in Paul. But the court also, as I've said, took the opportunity to revisit how some of the control mechanisms were being applied by lower courts and gave some important clarification where they said the law had taken an unfortunate turn. So first of all, does the claimant need to prove there was a sudden unexpected shock to the nervous system? And the short answer to that now is no. The court reflected on where this had come from, this language that we'd all been trying to apply, and considered that it came from an outdated description of psychiatric illness, a model that attributes psychiatric illness to an assault on the nervous system, which has long since been discredited. So the test going forwards is simply this: it's sufficient for a claimant who was present at the scene of the accident or its immediate aftermath, in which a loved one was killed, injured, or imperiled, to show that there is a causal connection between witnessing that event and the illness suffered. It is not necessary, even were it possible, to demonstrate the neurological or psychological mechanism by which the illness was induced. So we're back to ordinary principles of causation. Does the claimant need to prove that there was a particularly horrifying event? And you'll be familiar, many of you, with the fact that this is something that had been developed in cases like Shorter and Ronayne, where the court had considered the nature of what was experienced by a claimant. And the answer now again is no. The court said this: Lord Ackner's description of shock in Alcock had given rise to this notion that the claimant needed to prove that an event perceived was horrifying. In Shorter, it had been elevated further to horrifying by objective standards, and further gloss was added in King and Royal United Bath Hospital's Bath with the addition of the word exceptional. And the Supreme Court said there's no justification for superimposing an additional separate requirement that the event witnessed by the claimant must be horrifying. What the claimant has to show is that it was reasonably foreseeable that the defendant's negligence might cause her injury, and the Supreme Court gave an example of a case that might not succeed. So if, for example, a claimant with a history of psychiatric illness develops an illness after witnessing a minor accident in which his wife sustained some cuts and bruises, his claim might fail that test. So the test is one of reasonable foreseeability in relation to the severity of the incident. Does the claimant need to prove that what they witnessed was one event? Well, this again is something that's come out of the clinical cases that have now been rejected. And the simple fact now is that practitioners need to focus on whether what was witnessed was an accident or its immediate aftermath. And in terms of what is meant by immediate aftermath, I think following Paul, it's fair to say that the Supreme Court is encouraging the courts to be restrictive about that. They considered the case of Gally Atkinson and Segal, which was decided a few months after Walters, where a claimant went to the scene, wasn't allowed through the police cordon, didn't see a crash site, was told that her daughter had died. Then she went to the mortuary and saw her daughter's body, and that claim was allowed on appeal. Lord Justice Latham gave the lead judgment and held the immediate aftermath extended from the moment of the accident until the moment the claimant left the mortuary as an uninterrupted sequence of events. And that was derived from Walters. And the Supreme Court criticised this, saying we cannot regard the claimant's perceived motivation for seeing her daughter's body as a satisfactory criterion for determining the defendant's liability. And finally, the Supreme Court dealt with something that had come out of the Court of Appeal decision. Does the event have to be close in time to the negligent act or omission, so the underlying breach of duty? And this was something that featured quite heavily in the Court of Appeal decision in Paul. And the court said, no, it's very common for us as personal injury practitioners, this is me now, not the Supreme Court, to deal with cases where the event that unfolds can be as a result of failures weeks, months, and sometimes many years before. For example, if it's the negligent design of a building that collapses many years later. And the Supreme Court found that the authorities in this area don't suggest that the right to recover damages for personal injury caused by witnessing a person's death or injury is affected by the length of time between the negligent act or omission and the accident. So again, what is important is the accident, not when the negligence that went before it took place. Although, in many accident cases, the negligence and the accident happen very much at the same time. So that is my tour of the decision in Paul. It can be boiled down to some fairly simple fundamentals because it's a very restrictive decision. I think what one can say, whether one agrees with it or not, is that it certainly does bring clarity to this area to a large extent. Although Phil and I have been doing what lawyers do and trying to identify situations where we think that there may still be wriggle room. So Phil, should we have a conversation about some of the examples that we've been having a think about? I've got a new one that I haven't told you about. Okay. I'm going to add into the mix. It occurred to me this morning when I was thinking about this, so I'll wait to see what you think about it.
What do you think, Laura? Is it the first thing you look for is, has there been an accident? That's the most crucial part when you've got a client coming in with some facts. Got to identify that there's been an accident. And then in a clinical context, what could be an accident? Yeah.
And then there's the difficulties posed by this being something that is described as being violent external means. What does that mean? Does the accident in and of itself have to be violent, or can the violence be in reaction to what something's happened, in reaction to the thing that's happened, bearing in mind what the court has to say about the difference between an accident and the injury? So, Phil, conventional things we think might come within it?
Well, I'll pose this question to you, I suppose, is, well, one example I can think of is if there was an oxygen cylinder on the ward, somebody was attached to the oxygen cylinder, there was a defect, or somebody'd done something with the valve on the oxygen cylinder and that exploded. That's an accident. That's because in a clinical context that would satisfy the criteria. Obviously, if the person who witnessed the accident was had close tie blood and infection and was able to prove a psychiatric injury, I think that's pretty clear. Laura, you agree with that?
I think anything that looks like a conventional accident, subject to the issue of foreseeability, is fine.
What about during pregnancy? During the birth and baby's dropped?
Yeah, I mean, to me, that's an accident. This is what I've been thinking about, though, Phil. What about the scenario we see sometimes where, during the course of delivery, as a result of a negligent act, either usually by the obstetrician or potentially by an assisting midwife, you have a baby that suffers skull fractures and consequent brain damage, external forces, but in utero, is born grey, floppy, unresponsive in front of dad, resuscitated. Is that an accident? I think there's a perfectly decent argument that it is.
Yeah. Yeah. Of course, mum would qualify because she's a primary victim anyway. So if she had psychiatric injury, she'd qualify as a primary victim. So that we haven't got that issue with mum.
Yes, and actually, I think that's one of the questions that we've just been asked. What's the status of mothers I think at the moment it's relatively settled that a mother who suffers psychiatric injury as a result of injuries to her baby during the course of delivery is a primary victim, because those injuries happen when the baby and the mother are one and the same person. Although one can conceive of scenarios that become more difficult as you extend that timeline, but certainly that is the situation following cases like Wild. We've been
sorry,
given.
Gloria, just sorry, concentrating on your previous example about the delivery with some, I think you said with some force, but that would qualify.
Well, I
suppose,
questioned it.
I suppose
a settled view about it. does that count as a violent external happening? It's violent, and it's a violent happening to the baby, but it happens during the course of a cesarean section to a baby in utero. These are the and I should have said this actually. These are the questions that the court has explicitly left open, because during the course of argument in the Supreme Court, there were submissions on behalf of the NHS that appeared to accept that they thought that if you had a situation such as a doctor injecting the wrong drug, so the doctor causing through their negligent act an injury, and that was witnessed by a loved one, that might suffice. Now, I think what's important for everybody to know is that the court looks at this in paragraph 123 of the judgment and declines to go that far, saying, in our view, the issues raised by such examples are best left to be addressed in a case where they actually arise on the facts. Now, somebody has asked a question about a very sort of similar situation. So, misprescribed overdose of morphine to a child. Mother administered it to the child. Child collapsed instantly in the arms of the mother. Ambulance was called, and the child subsequently died. The short answer is the Supreme Court haven't decided that, and it's going to be another court that is going to have to decide whether that would count within the definition of an accident, a violent external happening. And it seems to be perfectly arguable that it does, subject to this caveat that the Supreme Court also makes this distinction between the accident and the injury. But when one looks at the ordinary reasonable person, which the Supreme Court was very keen to continue to hark back to in the judgment, it's a little bit difficult to understand why I ought to be able to recover if my mother falls in hospital in a conventional accident circumstances, and it's terribly upsetting, and she lands on the ground and injures herself and is very upset, and I can overcome the threshold of foreseeability and I should be able to recover seeing that. But if my mother's injected with a drug that causes her to have an immediate and dramatic, horrific reaction, and I witness that, I shouldn't be allowed to recover. So these distinctions are difficult to understand, and it's going to be something that I think the courts are going to have to grapple with, because we are aware of a large number of cases, certainly from people asking me questions about it, that suggest that this distinction between accident and non-accident in the clinical context is not as clear as it might be. But certainly what I think I can say is that the way the Supreme Court has approached this in Paul makes it difficult. Phil, do you have any thoughts?
No, I agree. I think it's that definition of the accident bit that's going to be complicated piece. But I think that the majority of cases that we've seen in the past will not qualify, because there is no accident as defined by the Supreme Court.
Because the vast majority are omissions, aren't they? They're failures to treat, they're failures to arrest the progression of an underlying illness or disease. And those cases, the decision in Paul makes it absolutely clear, will not be able to succeed.
Yeah.
So it remains the case that you need to be looking for whether or not what has happened can be properly characterised as an accident within the definition given by the Supreme Court. On the upside, impersonate for claimants, in terms of conventional cases where there is an accident, the court's comments on causation and shocking and horrifying event reset those thresholds to make them somewhat more straightforward to overcome, I think. Would you agree with that, Phil?
I would agree. I think when the question's asked, would it lead to more cases? I don't think it will lead to more cases, though, because obviously you still have to show all of the other criteria that, close to a tie of love and affection. You've still got to show psychiatric injury. You've still got to show that you were there present at the scene or the immediate aftermath. And I think maybe the Supreme Court have indicated, the extent of how long is the immediate aftermath is going to possibly be a feature in some cases, but I think the indication is that it's going to be a fairly close time to the event. It's not going to be prolonged as it was with the other cases, Gary Atkinson, etc.
Yeah. One of the other questions we've been asked is what impact do we think that this will have on motor injury cases? I suspect not a significant impact, because I suspect for the most part, in a motor accident case, if you had somebody who was present at the scene and had that close tie of love and affection and could demonstrate the caused psychiatric injury, the hurdles that have been, I think, perhaps lowered, horrifying, and an assault on the mind were probably more straightforward to overcome in those circumstances anyway. So whilst it's made some of these claims somewhat easier, I doubt very much it's going to have a sort of floodgates effect on any of the conventional accident type cases. Some that were perhaps more marginal over whether something was shocking or horrifying will succeed now where there might have been room for argument. But in many accident cases, those hurdles actually weren't in reality such a challenge in any event.
Laura, I'm conscious it's just 1 minute
we've
past
reached 1 o'clock.
one.
So we will tie up there. I don't think we've got any questions left that we haven't answered, but thank you very much, everybody, for listening. I'm just having a quick look. I will come back, Kirsten, to you by email, and Nicola as well. I'm happy to pick up a discussion with you offline. So thank you very much, everybody, for coming. I hope it was helpful and interesting. And as I say, you will be sent a paper on secondary victim claims that will also be available on the Deka Chambers website and through our usual channels. So thank you very much. And thank you, Phil, for joining me. It's been a real pleasure.
Thank you, Laura. Thank you, everyone.